Okay, so good morning, everybody. I am Evelyn Blanco. I have been in the HR discipline for over 20 years, and I want to thank you for joining us today. I have been presenting these webinars for over approximately 2+ years, and we've been fortunate enough to have Robert Huddock from Huddock Employment Group join us as well. Robert is our end-all, be-all labor attorney, and we refer to him for all of our needs. And we're very appreciative of your being here today, Robert. Thanks so much.
Glad to be here. Thanks.
Yeah, you're welcome. Thank you. So we are going to be reviewing all the new laws for 2020 today. Excuse me, I lost my train there. For the new year coming 2023. These will be reviewed each individually. We're going to go over some points, and then we'll be asking Robert some direct questions as well as opening questions to the audience. So again, we thank all of you for joining. We know how busy you are, and we appreciate your taking the time. So Robert, let's just dig in. So our first, we're going to be going over the 6 new laws that we believe affect our employers the most, beginning with COVID-19 relief, supplemental paid sick leave extension, employment leave AB 1041, employees bereavement leave AB 1949, discrimination in employment, use of cannabis AB 2188, employers emergency condition SB 1044, and last but not least, employment, salaries, and wages, SB 1162. So the first topic is COVID-19 relief supplemental paid sick leave of AB 152. So Robert, we already know, most of us, if we don't know, hopefully know. If you haven't already known, excuse me, the supplemental sick leave has been extended until the end of 2022. If you have not already, you should have received the posting and placed it with all of your other labor law postings for all of your employees who have access to view. Additionally, if you have remote employees, this posting should have been sent to them so that they're aware. There will be a follow-up email to the webinar where I will include the required posting for the extended supplemental sick leave in case any of you do not have it. And I just want to emphasize, this is not a new bank of sick leave. This is just the existing banks that were already in your employees' supplemental sick leave that has been extended. So Robert, I think one of the biggest burning questions for most employers now in California is there or possibly an expectation that this will be extended indefinitely, that COVID would be an extended, or excuse me, that COVID supplemental sick leave might be an extended arm of California's existing sick leave?
Well, I would say that there's no information, no meaningful information with respect to whether that would happen. We can make some, we can have a hypothesis maybe. And what I mean by that, to put it into context, is, you know, that we have California state sick leave, and that's limited. And then you have the patchwork of municipal ordinances in various places that provide various different types of, various amounts of sick leave and ways in which you provide it, et cetera. I suppose it's possible one could reasonably hypothesize that maybe California would want to make the entire state consistent and come up with a more comprehensive sick leave law that applies everywhere in California, and therefore make the amount that's required under California law consistent or more consistent with those municipal ordinances that require more. I think that's the only guidance we have in terms of whether that might happen.
So if I'm understanding you correctly, for example, I know that Los Angeles, the County of Los Angeles requires that employers provide 48 hours of sick time versus the state requirement of 24. Are you saying that that there's a possibility that they would increase the 24-hour statewide requirement to more to match up.
That's the type of thing I'm referring to. So I'm not saying
Okay.
that the amount that was used under these, emergency conditions under COVID is necessarily the amount that they would choose. I just wonder,
Right.
is this going to be a convenient point at which to
makes
align
sense.
everything? So
completely makes sense. Additionally, on this particular law, for those of you who have not heard, there is a grant available for qualifying businesses, small businesses, and nonprofits. So you want to be sure to check with your CPA and or banking institution for if you qualify. Okay, here we go. So our next one is employment leave, AB 1041. So this particular leave, I think, can be confusing, some of the language, because many people, in general, the California leaves can be confusing. You have some that run concurrently, some that run consecutively. And because these can be so confusing to track and maneuver, I would always highly recommend that each employer reach out to an HR professor, their HR professional, and or a labor attorney to provide with guidance and compliance. That said, because the law is reinforcing the fact that you have to provide job protection, and it expands the definition of what is a designated person. So Robert, in layman's terms, can you tell us what is a designated person?
Well, the term designated person is a new term used with respect to, and I'll get into this part a little bit later, but with respect to both job protected leave and sick leave. But what we're talking about here is time off to care for someone else. And so the definition for who is included, which types of family members are included, has been expanding progressively over a few years. So now California is taking a more sweeping approach and saying that leave can be taken to care. When you talk about family members for whom you can take time off to care for, it is a designated person. And designated person for this purpose has its own definition. And that's an individual related by blood or whose association with the employer is the equivalent of a family relationship. Now, you can probably immediately see an issue with applying this. What is what is the equivalent of a family relationship? Well, we don't know that yet. Unfortunately, there's not any language within the law, and there's not any current guidance as to who that might be. And that makes it almost impossible to appropriately apply and appropriately use. But I suppose in that instance, I would say err on the side of inclusion, at least until we have some more guidance. Maybe the administrative agency that deals with this will put something out at some point, maybe before 2023. I would expect that to happen. But the point right now is there is no further definition there. But I would expect some guidance to come out. Now,
okay.
With respect to, so we have family and medical leave. That's the FMLA, the CFRA, and you can take medical leave, obviously, for your own serious health condition, and then you can take family leave to care for a family member who has their own serious health condition. So the designated person is now the scope of the family members for whom you can take job protected leave. Now, that new term of designated person and its definition is also being used with respect to sick leave. And specifically what that means is to care, an employee can take sick leave, can take time off using sick leave to care for a designated person. It doesn't have to be their own sickness.
Okay. And so I think like the average person would think, okay, you know, family relationship, if I was raised by my mom's best friend, or, you know, the term like my aunt, that sort of thing, but not necessarily a blood related aunt would apply. And yeah, this is going to be a maze for all of the employers to navigate. Okay.
Yeah,
And
yeah.
then
So like I said, I would expect some guidance to come out before it goes into effect. We still have another 2 months, and I would be surprised if there wasn't. And then the other thing too is with respect to eligibility.
that was my next question.
Yeah, stating the obvious, but when you're talking about leave, you have those longer period of employment requirements, whereas with sick leave, it's only 30 days. And so keep that in mind.
Yes, because the language in here refers to the 30 days, which I think would have caused confusion amongst employers, but it's still, in order to take the CFRA or any of the other leaves, you are still required to work the 12-month period, but for sick leave, it's the 30.
Yeah, and with the bill, it's simply that it's injecting a new term with its own definition into two distinct but similar areas, meaning, okay, designated person with this definition is going to be used for purposes of family leave, but it doesn't change anything else about family leave. And it refers to the 30, an employee is someone who works for 30 days and so forth, only with respect to the sick leave. It's distinct.
Right. Okay, we do have one question, and the question is, what is the difference between AB 1041 and federal FMLA? And I think they're two separate, please correct me if I'm wrong, Robert, but Federal Family Medical Leave Act is an entire leave, whereas 1041 is just honing in on the definition of the designated person, what that definition is.
Yeah, so let me say this. The FMLA is the federal law that governs family and medical leave. The state law that governs in California is the California Family Rights Act. And the California Family Rights Act provides greater benefits and better protections for employees. So it's always going to be the act that has those things that applies. And so if you're talking about an employee in California, you're going to be talking about the California Family Rights Act. Now, the California Family Rights Act has differed from the Family and Medical Leave Act in terms of the family members that are included in those that you can take protected leave for. That's been expanding in California for a while. So as of, I think, maybe 3 to 4 years ago, it started going beyond the FMLA. This just takes it even further.
Okay. Okay, moving right along. Okay, so now we have employees bereavement leave, AB 1949. And I'm not going to read through the entire slide, but basically, currently, most employers give a day or some time for bereavement, and some provide pay and some don't. But as of 1/1/23, all employers, regardless of size and headcount, are required to provide up to 5-day bereavement leave. The law does not require that you pay for this leave, but each employer is it's their decision whether they want to pay for this or not. It's up to the employer and their organization if they want to make the bereavement leave paid. Also, if the employees have sick or paid time off in their banks, the law requires employers to allow employees to use those hours for the bereavement leave. This is a benefit, I believe, that really buys goodwill for employees and is appreciated by employees when they are in most need. And it often brings about loyalty and appreciation for their employer. Robert, I know that this is part of a ruling employers are allowed to ask that as part of this law, employers are allowed to ask for proof of death certificates or, obituaries. Do you foresee this becoming an issue if it is done on a case-by-case basis? I mean, we all know that the rule is what you do for one, you do for all, or hopefully we all know that. But I mean, it is difficult. I know that depending on the size of organization I've worked for, in some cases we've asked for it, some cases we haven't. What's your guidance on this particular?
Well, best practice, independent of administrative burden, is to ask everyone for it. And this is true, like you were just saying, Evelyn, this is true for anything that you do in the workplace, because anytime you start treating people differently, you expose yourself to someone claiming that the disparate treatment was based on a protected category rather than some other consideration that it actually was. And, evidence in disparate treatment cases can be circumstantial. And so someone could say, well, they asked Jane Jones and these other 5 people who are, of this race, or they didn't ask them, but they asked me, and I'm in this race. And right. Someone try to make something out of it, even though there's in fact nothing there. And that another example of that would be if an employer has a requirement that someone coming back from leave have a fitness for duty certification, a doctor saying that they're ready to return. Right. That's one area where those types of arguments have been made. And so it's a good idea to require that across the board. So that's my thought on that. Okay. I suppose there are strategies that you could try to develop if it is an incredible administrative burden, but that would have to be thought through on a case-by-case basis. Right. And there's a couple of things I want to add to, I think that might be of interest to people with respect to bereavement leave. Number one is the 5 days of bereavement leave is in addition to the 12 weeks of leave for California Family Rights Act, family and medical leave. I mean, it makes
separate leave.
Yeah, it makes logical sense because it's really not to care for a family member, but just to be clear, it's in addition to that. Also, and this may be part of, this could be also where confusion of 30 days gets mixed up or what have you. And that is for bereavement leave, an employee needs to have been employed for 30 days. And that happens to be the same definition for who is an employee entitled to sick leave under California law. So it's essentially the same there, but it's good to know that they can't do that within the first 30 days, or it's not a requirement. You can choose to do it, of course, but it's not a requirement there. And the other thing is who are the, and it's a similar question to what we were talking about before, who are the qualifying people for whom you are required to provide bereavement leave. And that's not where you have a designated person. That's not injected into this particular thing. The family members or the people for whom bereavement leave is required is spouse, domestic partner, parent, parent-in-law, grandparent, grandchild, child, or sibling. And that's what was the CAFRA definition prior to this designated person being injected into the CAFRA.
So it's probably safe to say that the trend will probably continue down through all the leaves, don't you think?
It would seem so.
The designated person?
But it would seem so, but then it would have been very easy for them to just use designated person for purposes of this as well.
True.
So
true.
It was just writing it in there too. So I don't know.
Yeah.
But for now, it's not. And the other thing too is bereavement leave doesn't need to be taken all at once. It can be taken intermittently.
Ah, okay. Which actually we have one more question, and that's actually on our previous on AB 1041, the employment leave. One of our attendees is asking, can the coverage be scattered one day here, one day there for family members who have sudden illness episodes, for example, diabetes episodes?
So I think the question is, if you're taking leave to care for a family member, can that be done intermittently? And if
right, which would apply to FMLA, CFRA, and that's a yes.
Right. So if I have the question correct, then yes, any kind of leave can be taken intermittently.
Okay, great. Thank you, Robert. Okay. Okay, this is an interesting one. Discrimination in employment, use of cannabis, AB 2188. So we have to get ready. Although this is not effective until 1/1/2024, we will all need to prepare. When I read this, so many questions ran through my mind. I was just kind of overwhelmed. But, and I'm sure that's the questions many of our attendees, as well as employers across California, are wondering about. But, you know, the first question that came to my mind, and as I was talking to a few people I know, is like, what does an employer do if an employee tests positive for cannabis? How is it determined when it was used? For example, you know, now we can, you know, as of 1/1/24, and it's been legal in California for a few years now, if an employee was using it last night, comes to work, tests positive, how is it going to be determined if if they used it this morning or it wasn't last night or even over the weekend?
Well, the one thing I'll say about this bill is with this bill, California is starting to distinguish between marijuana or marijuana derivatives that impair your ability to perform your work and those that don't. And the term that's being used is psychoactive cannabis metabolites or non-psychoactive cannabis metabolites. And California is saying now there are reliable tests that test only for the psychoactive cannabis metabolites. And so what this bill puts into place is they're saying you cannot discriminate against anyone for, you can't do a test and then have some kind of adverse action based on the fact that they tested positive for non-psychoactive cannabis metabolites. For those that are the psychoactive metabolites, you can, but there are also a number of other requirements that still apply or that accept people from this rule. So, for example, employees and applicants in like building or construction trades, and those who are subject to mandatory federal background checks, this bill does not apply to them. And it also does not apply, or it does not preempt any state or federal laws requiring applicants or employees to be tested for controlled substances as a condition of either employment, receiving federal funding, or federal licensing related benefits, or entering into a federal contract. As you can see, these are very specific situations. It's going to be a state or federal law which has there's an existing law saying in this field you need to be tested, and for those this new law doesn't change it. But as I mentioned, the key thing that is being started with this bill is, if you're going to do a test, if you're not one of those employers like building or construction or some of these other things that I just mentioned, and you want to do a test, you want to make sure it's a test for the psychoactive cannabis metabolites and not the non-psychoactive, because if you detect non-psychoactive, it doesn't mean anything, and it only creates a factual situation that somebody could try to latch onto. Well, why are you testing for that if it's not relevant?
Right.
And that type of thing. So just to sum up, the bill is saying that you cannot discriminate against an employee in hiring, termination, or any term or condition of employment, or otherwise penalize an employee if the adverse action taken. Now, here's what gets into your question, Evelyn. If the adverse action is taken based on the employee's use of cannabis off duty and away from the workplace.
Right.
And so I think what I understood your question to be is, let's say someone comes in. Well, let's say someone uses marijuana. They smoke marijuana 3 hours before their shift, and they come in. I would say that, strictly speaking, because they used it off duty and away from the workplace, strictly speaking and technically speaking, that's something for which you can't take an adverse action. Now, that doesn't necessarily mean that you can't do something for that day. It's just that you can't use that necessarily as some kind of evidence of that will ultimately be used to make a decision. However, I would qualify that by saying, if the person is very noticeably impaired, then you have to do something. And in such a case, I don't think that there would be such a strict interpretation of off duty and away from the workplace. And one thing you could do is, I personally, I don't know how rapid these tests are. But if you do have a doubt and the test is rapid, or there is a rapid test, that's something you could always do, because that's going to show whether there is that psychoactive metabolite in their system as a result of having it just 3 hours before.
Okay, this one definitely spurred some questions. So we have a couple of questions from previous slides, but let's address the two regarding the cannabis. So our first question is, what is the difference between being alcohol impaired over the weekend versus cannabis impaired over the weekend?
There is not, legally speaking.
Okay, that's what I thought.
However, I will say this. I need to qualify that. I need to be very precise. I would need a little more information about what the question is asking, but I would need a little more information, because are they saying like they come in after the weekend and they're still impaired? And how does
that's how I understood it, that, so I think it's one thing for somebody to come in, quote unquote, with a hangover, whereas, somebody goes out, Sunday football, drunk, keeps drinking, and wake up still somewhat impaired.
Yeah, I think that probably is the type of situation that I was just describing. That theoretically, you could do an alcohol test for that person who was drinking, and you can also do one of these metabolite tests for
cannabis.
For cannabis, and in that sense, there is no difference.
Right, which actually falls right into the next question about this particular law as well. What can be done if the employee is noticeably impaired? which would go back to, you know, reasonable suspicion and having them tested if it's actually visually noticeable that they're impaired, right? Would that be correct?
Yeah, and what we're talking about here, it does get nuanced, but let's just take a one-off incident, you know, where that somebody comes in and they seem impaired, and you have to make a judgment call, because you both have a duty not to discriminate, but also a duty to keep the workplace safe. And so
Exactly.
if you've got some evidence to back up your, you know, you have a reasonable suspicion that that person is impaired and endangers safety, then, you know, that's going to outweigh any considerations with respect to that one day that you do that. It becomes a more of a line drawing exercise if you're talking about, you know, perhaps there being more than one day, or using any particular instance as grounds for a later termination in conjunction with other information or evidence. But I think that, you know, when we're talking only about one particular day, that's not what the law is getting at. And I think that if it's a safety issue, it's going to be something where you're on all fours and you'll have a good defense.
Okay. So our original attendee said to clarify, her staff have questioned, since marijuana is now legal, can they use it over the weekend but have no impairment upon return to work? And I think that the answer would be yes. Just
the
like
answer is yes, because there is no distinction now between alcohol and cannabis in that scenario.
Right.
It's you could think of it as the same thing, you know, as a rule of thumb.
Okay, this question says, we do background checks through the Department of Social Services Care Provider Management Bureau. Are we excluded from AB 2188?
Yeah, I can't say specifically with respect to that field, but it sounds like one of those ones that would be accepted from the new assembly bill.
Okay.
Because it, as I mentioned before, this law does not preempt any state or federal laws that require employees to be tested for controlled substances as a condition of employment. And I think that that's what you're saying. I mean, it's either a condition of first being employed or continued employment. And in either instance, those are exactly the situations in which the new rule under whatever number it is, 2188, not going to apply. It doesn't preempt it.
Okay. Yeah, so basically, if I understand you correctly, you're saying on the face of what this attendee is asking, it sounds like, yes, they would be exempted.
Correct.
Okay. Okay, then we have a couple of questions. Going back to a first few slides, do all of these new laws apply to companies of all sizes? So I know that, so in regards to supplemental sick leave, it's I'm drawing a blank on the head count, but over 25, is that correct?
Yeah, 26 and over.
26 and over.
It's saying the same thing in two different ways.
So sorry, say that again?
Saying 26 and over is saying the same thing as over 25.
Yes, true. Okay, and then California Family Rights Act, or CFRA, it's any employer over 5 employees.
5 or
then 5 or more, yeah. Did I say that? Sorry. And then FMLA is still 50, correct?
FMLA, yeah.
Yeah, okay.
But it really, like I said before, it's kind of doesn't matter if you are dealing with employees in California. What the FMLA says regarding what the threshold is, or who qualifies for leave, doesn't matter, because CAFR provides broader
right.
Yeah. So,
and then the bereavement leave, I know, is employers of all size, regardless. You have 2 employees, you have to honor the bereavement leave. And then the next question we have is regarding the bereavement leave. Is the 5 days of bereavement, is that per year or per passing? Meaning if I, in January, lose my parent, and then in July lose my brother, do I get 5 days for each death, or is it 5 days a year?
I don't want to misstate.
Right.
Yeah.
I think this is something we want to need to verify, because I honestly don't remember seeing anything on identifying how many times per year this can be used.
My sense is that it could be multiple times, because as long as it's one of those qualifying people. And I guess that, you know, the thought behind it could be it's controlled in some way, because how many, you know, but some people have big families, but again, it's spouse, domestic partner, parent-in-law, grandparent, grandchild, child, or sibling. So at least it's not going out to designated persons now, because then that would make it, you know, something that, you know, you'd be giving more leave than certainly you'd want to, or certainly that was something that in the workplace that was good.
Right. Okay. That's all the questions so far. I think we had a panelist by the name of Janelle that might have raised your hand. If you could please just enter your question into the Q&A chat, I would appreciate it. And I'll be happy to read it out loud. Okay. So then our next law is Employers Emergency Condition, SB 1044. And this one, I thought, with everything we have going on in the world, it's somewhat apropos. But so basically, what does this mean? I interpreted it to mean that in the event of, God forbid, a live shooter, wildfires, hurricanes, you know, anything where an employee feels unsafe or has to address danger for their home, a family member, their children, there cannot be retaliation if they feel that they have to leave because they feel unsafe because there's a live shooter either in their own employment building or across the street, or if they get notification that their child's school is on a lockdown, or they get, like I got last year, you know, one of those alerts that says, you know, there's wildfires in your home area and you may be put you on notice that you might be evacuated, that there cannot be retaliation if I choose to leave my employer to handle that situation. It also means that but there's caveats to that, correct? So that, meaning that if an employee feels that it's unsafe because, you know, there's a puddle in the walkway and they feel unsafe because they might slip, you know, that it doesn't apply here. The puddle needs to be cleaned up and I need to stay at work. Or, you know, because of I'm sick and I hear somebody coughing and I'm fearful I might catch COVID, I can't leave because of that. Can you, because we have all of these things happen so often and there are requirements for us to be sympathetic and empathetic to our employees, what is the best way to address this? And also, the law doesn't outline what are the pay requirements if an employee chooses to leave, but what can you give us some guidance on, Robert, with best practices for handling the situations and whether we do or choose not to pay the employees? Can you just give us a little overview of how you would, if I were to call you and say, I don't know what to do, what you would say to me?
Yeah, I have a few things to add. With respect to the definition of emergency condition, the theme is a unsafe condition caused by natural forces or a criminal act. You may have said that already, and if you did, I'm just reinforcing it.
I didn't use those words, but that was my message.
Yeah. So that's a rule of thumb to use. But of course, natural forces is something that's going to cause definition problems. And maybe one example would be pandemic, a health pandemic. Is that natural forces? Well, apparently not. An emergency condition it's been stated that an emergency condition does not include a health pandemic. So this one, or this definition, is like that definition of designated person when it talks about the equivalent of a family member. What does that mean? But I think that it's going to be something that is a catastrophic is too strong of a word, but something that isn't isolated. It could be isolated to that workplace, but it's something that affects a group of people collectively when we're talking about natural forces or a criminal act. Now, with respect to pay requirements, as you mentioned, there's nothing stated specifically within the bill. What we do know, however, is number one, we know that the general, under California law, the general bias towards employees, providing them the most protection, providing them the most leave, providing them the most payable time, so on and so forth. And so with that being the case, the best practice is always going to be err on the side of including the pay, because really, it's only in a very, very rare circumstance where a condition like that is going to be something that expands over some period of time, where paying the leave may become a serious burden. But again, there's all kinds of hypotheticals you could come up with. So I guess the end message is err on the side of inclusion. So if you're just talking about a day, 2 days, 3 days, whatever, just pay it. It's easier to do that than the trouble that you might invite. And if it does become longer, then there can be some more looking into, because then there's going to be in situations where it extends, there's going to be other types of laws that apply that may change whatever the analysis is and what the conclusion is with respect to whether or not it needs to be compensable. Did I address each part of your question, or?
Yes.
Okay.
Yes, you did. And I do have one follow-up. So one of the things that I was talking to somebody about recently when we were discussing this particular law is, so for example, when I mentioned that I received the alert on my phone that I was in the area of possible evacuations, how do we know if an employee is telling the truth? And for example, so when this happened, it was last year when the Laguna, all those mansions up in, I want to say Laguna Niguel or up there, there was a bunch of them that just went up, that blew up in flames and were demolished. So I'm at the bottom of the hill. And so I got a notification of possible. But what if somebody says, oh, they're evacuating my area, and they live like Santa Ana, let's say, nowhere near, but they live in Orange County. How do we just take an employee's word for it? I mean, if I have a company that's 25 employees, I can look it up. But if I have an organization of 150 to 200 or more employees, I can't look it up and have to take the employee's word for it. Like, how does an employer address that?
Well, the thing is, if I understood your example correctly, you were talking about a condition outside of the workplace or work site.
Correct.
That
Correct.
being the case, Senate Bill 1044 doesn't apply, because it's about an emergency condition that causes the workplace or the work site to be unsafe.
I'm a little confused.
Well, you're talking about an unsafe condition, as I understood it, you're talking about an unsafe condition in terms of getting to work.
No, I'm talking about if I'm at work and I get a notification that says my home might need to be evacuated and I need to leave.
It would fall under something different. This is about unsafe conditions at the workplace or at the work site. You're talking about a condition that's
Oh, okay.
in your
I
home,
understand.
the area where you live.
Well, well, it's if I'm looking at the slide we have up right now, it says under this emergency condition means existence of either number two, an order to evacuate a workplace, a worker's home, or the school of a worker's child due to a natural disaster or a criminal act.
And so
do you follow where I'm going?
I do. And so I suppose, because we're talking about evacuate a workplace, we're talking about evacuate a work site, but then it goes on to say a worker's home or the school of a worker's child.
Right. So, I'm at work and I get a notification, your child's school is on lockdown, or you need to come get your children because they need to be evacuated, whatever the case may be.
Yeah, I mean, the bill does apply to refusing to report to or leaving a workplace or work site because the employee has a reasonable belief. I mean, what it's aimed at is either leaving or coming to the workplace or work site, but it looks like they did. The scope is a little wider there, and
right.
You know, reading it plain language, it would seem that the same definition of natural forces here. I guess they use it a little bit differently. They say natural disaster, I believe.
Or a criminal
act. And so in that instance, with that language, they've expanded the scope.
Right.
But so, it's still a little bit limited because it's limited to the worker's home or the child's school.
Right. So I would say that if I got, personally, if one of my clients called me and said, what do I do? I would just take the employee's word for it, unless all of a sudden unless I see a pattern of behavior where it's constantly happening. You can't.
What I'd comment on that is if the condition is something that qualifies for being a natural disaster or criminal act, that's going to be information that's readily available. If I understand what you're asking me.
Yeah. No, well,
so words, I'm
sorry, I didn't mean to make this so.
Yeah, you say take their word for it, saying they're reporting of this natural disaster or criminal act. But it would seem that if it's something that's of a serious nature like that, it's not going to, you can confirm it outside of what an employee might or might not tell you.
Right. Okay. Well, thank you. We do have a couple more questions. So can an employee leave if they feel unsafe if a protest is going on near the workplace? If they feel unsafe that a criminal act might happen around the area? Great question.
Yeah, that is a good question because it tests what the lines are. And really, we do have some line drawing problems. But I'll say this. Number one, there is a reasonableness requirement. Whether that adds anything to the definition or not is up for debate, but it has to be a reasonable belief that the workplace or work site is unsafe. So if what you have outside, this is the way I'd parse it out. If what you had outside was just people peacefully marching down the street with some signs and maybe yelling a little bit, and they want to say that that's a dangerous or unsafe condition. And now remember also, it has to be by natural forces or a criminal act. So in that instance, the type of activity probably wouldn't qualify, but for purposes of demonstration, as far as the reasonableness is concerned, or how a reasonableness requirement works, you wouldn't look. I don't think that kind of protest would be something that would be a reasonable belief of whatever. Whereas if somebody people have weapons or there's fights going on, that's going to be a different story.
Right. Okay. And then the next question we have, I'm sorry, I didn't hear if sorry. There are many employees who feel the workplace is unsafe due to COVID risks. Will they now have an excuse not to work in the office? I think we did address this and say that that's not considered a natural disaster or a criminal act. So the answer would be no, because that's a pandemic and it is excluded, correct?
Yes.
Okay, thank you. Then we have the question of, oh, sorry, didn't hear if the employer has to pay the employees when they feel unsafe and want to leave. So yes, we did address this and said that more often than not, it's probably going to be in your best interest if it's a day or two to pay your employees. If it becomes an extended amount of time, then that's something as an organization you'll have to discuss. But generally speaking, it's probably best practice to pay for a day or two, and then anything beyond that would be discussed as an organization, right?
Yeah, and I'll add something to that. So in terms of have to, there is no specific, there's no law specific to this new standard that says you have to pay. However, you could look at another situation like reporting time pay. It's a little bit different, but there are some similarities, right? Because if a worker shows up for work and the employer can't put them to work for their regularly scheduled shift, you got to pay them for a couple hours. However, there are exclusions for things like acts of God. But I guess my point is there are a number of other principles and laws or guidances on which you could rely to come to the conclusion that it's at least a best practice and a safer way to go. But I'm not aware of any law currently indicating that it is a requirement when you have this emergency condition to pay, because really what this is dealing with is adverse actions. It's not addressing wage and hour issues.
Got it. Okay. And one more question. Going back to the California marijuana related laws, can employers still have a zero tolerance policy concerning what the federal government determines as a illegal or prohibited substance abuse?
I guess in other words,
well, I would say, wouldn't it be yes, you can have a zero tolerance policy of being impaired at work? It's still zero tolerance.
Yeah, I mean, I guess it's what you have zero tolerance for.
Yeah.
But I guess I'll answer it this way, and hopefully this answers it. The fact that federal law still considers cannabis not legal isn't going to change anything with respect to what you are subject to under this Assembly Bill 2188. Maybe that answers the question.
I would think so.
I think that's maybe what the attendee was getting at. But if it's not, please write again and we'll address it.
Yes. Okay. Great. Thank you. Okay. And then last but certainly not least, employment salaries and wages, SB 1162. So this one says that requires additional information. I am going to read this one. Requires additional information be reported to the state of California on the employer's pay data report. For example, the bill requires employers to report the median and mean hourly rates for employers. It also requires employers who hire an employee through labor contracts to submit a separate report for those employees. The bill further requires that employers to provide a pay scale to any current employee for their position currently working upon request. And in addition, the bill requires employers with 15 or more employees to include the pay scale for a position in any job posting. Existing law requires employers to provide a pay scale to an applicant upon request. So now, 2023, when I post a job on Indeed, I'm going to have to say, I'm going to pay, for a receptionist, hypothetically, $20 to $25. Now, if it's, depending on the level of the position, what is the best way to approach this? Because as an employer, I do not want to, scare off any potential candidates by putting too low of a range. Is the best practice just to put a very wide range? And is that compliant?
As far as I believe, you can put whatever range you want to put. However, I guess there would be a risk of, if it was ever looked into, so to speak, and the people that you had in that position were, it didn't cover that whole range, and really it was, in a much smaller range, somebody could raise an eyebrow, but, that's not something certainly that's defined in the law. All it says is to include a pay scale. You use your best judgment as to what is a reasonable thing to say for your pay scale. And keep in mind, within your example, that's when you have 15 or more employees.
Right,
so,
right.
Yeah, the job posting is for 15 or more employees.
Okay.
And then just to address an earlier attendee asked a question about thresholds of number of employees with respect to these laws. Well, there's another one here with this law, which is employers with 100 or more employees are required to, there's new pay data reporting requirements, and submitting the reports to the California Administrative Agency that deals with this.
Right. Okay, we have another question. It says, if a position only has an hourly rate and not a range, would that still be okay? Well, I believe, Robert, that even if there's an hourly rate, there's still a range. So $10 to $15 an hour, $15 to $20 an hour. It doesn't have to be an annual salary, right? Well, I'm not sure.
You could always state just one. You wouldn't have to state a range if indeed there isn't a range and there isn't going to be a range. So if
it's always paid at the same amount.
Yeah, if you know that all people working in such and such position, are paid $20 an hour, then you can put like what's, and some people that is done sometimes in existing postings or whatever, but you're not limited to putting just one. You can leave things open if you want to, but if the starting pay is indeed going, well, the pay scale, I guess the question becomes, what if you have only one, right? And maybe that's what this person is asking. Like if you have, if you have only one existing employee in some position and you're hiring somebody, really, the pay scale would probably most accurately be what that one existing person is being paid.
Correct. Yeah.
Yeah. So,
or if all of the positions are minimum wage, then depending on what city or municipality you're in, correct, it would be minimum wage.
Yeah. So the only time I guess you would be required to include a range is if there is in fact an existing range of people who are actually working in that position.
Got it. Okay. And then the next question is, I would think the recruiter would need to take into consideration the federal exemption salary minimum and the hourly rate based on the city or state minimum, whichever is higher, correct? Of course, that's a yes.
They would have to take it if they wanted it to be an exempt position. Is that the question?
Right.
Yeah,
I think so. They're saying, but at minimum, you have to meet the way I'm understanding this is at minimum, you have to meet whatever the minimum rate, minimum wages are, whether it be for a salary exemption or an hourly rate based on the city or state minimum wage, whichever is higher.
You still have to comply with all other laws that otherwise apply.
Got it.
I may have misunderstood the question, but that's what I can say to what I understand.
Yeah, I think that answered the question, but okay, well, that is, oops, sorry about that. I went back a few slides, my apologies. That is the end of our presentation, but we have another question. If a position only has an hourly rate, okay, no, I already answered that. Sorry about that. Okay, we did answer that last question. And do we have any other questions from our, oh, we do, we have one. Concerning pay range disclosure, would it be a requirement or best practices for employers to have some sort of compensation plan in place with salary / pay bands, grades, like non-exempt, etc.? I think that depends on the size of the organization.
Yes. There's a lot of things that could make the answer to that question one thing in one situation and another thing in another situation. But generally speaking, I think you're right, Evelyn, that, you know, if you have a larger organization, you're going to want to have more structure. Whereas if it's a small one, you may not even have enough data to have that kind of structure.
Right. Okay, we have one. Can you define what number of employees mean? 25 employees at the time the bill is used, or some 941 average?
With respect to?
So I believe what this attendee is asking is that if, for example, if I am using the sick leave, you know, does it apply? The 25 head count, is that at the time the bill is passed, or an average across the year, or when does it kick in? And I know I've been asked this by my employers, and I always tell them average. I specifically have one client that they go up and down, and I always tell them, because they're always on the cusp. Sometimes they're at 24, sometimes they're at 27, 26, you know, they balance. And I always tell them, to be safe, and in order to avoid yourself any problems, I always say, you're always so close to that 25, 26 employee mark, just pay the sick leave. Because that one time that they think they don't have to pay it when they're under the 26 mark will be the time that an employee comes a knocking. That's been my best advice. What are your thoughts?
No, I don't have anything to add. If you're hovering around that range, that's going to be your best practice. If you're asking yourself that question, that would probably mean that you're hovering around the range.
Right.
And in such a case, you know, if it's not resulting in a wide swing of what your labor expense is, then it's going to be something you want to err on the side of paying.
Right. Okay. I've gotten this question a few times, and I just want to let everybody know, yes, after the webinar is completed by probably end of business tomorrow, you will receive a copy of the recording with the PowerPoint presentation and the posting that was promised at the beginning of the webinar. And then we have a couple more questions. So per pay scales, does the employer need to post the pay cycles for all positions within the company for all employees to see?
I don't know what pay cycles means. Do you, Evelyn?
I think so. So often what happens with some organizations, Robert, is you'll have hourly or non-exempt employees paid bi-weekly, and then your exempt employees paid semi-monthly. So there's two pay cycles.
Yeah. Well, if you're saying like what measure do you use for the range? In other words, for 1 hour, for 1 week, for semi-monthly, how much semi-monthly, how much annually? I think you can use any measurement, if that makes sense. Am I understanding
right,
correctly?
I think so.
The range is 1,000 to 2,000 weekly, or the range is 3,000 to 5,000 monthly, or bi-monthly, or excuse me, semi-monthly or bi-weekly. If that's what the question is, there's no standard to how you have to state the scale, or on what basis you need to state the scale, or for what period of time, or anything like that. If it's an hourly, you're going to want to incorporate hourly in there somewhere. If it's salary, you're going to want to state it in terms of the salary.
Okay. And then we got clarification on one of the previous questions. Are there, excuse me, are there any exemptions to salary reporting? And if so, where can that language be found?
Salary reporting, meaning the ones for 100 or more employees. I don't know the answer to that as I sit here.
Okay.
And this is new. So I don't know if, for example, there are certain exemptions to, for example, the EEO type reporting that may apply here. I just don't know the answer to that as I sit here.
Oh, okay. So they're specifically asking, for example, organizations that are nonprofits or religious affiliated. So for that attendee, we'll do a little bit of research and see if we can't get you some information. And if we do, we will include it in the email that is sent out upon finishing the webinar. I think we answered this. We answered that one. Okay. Any more questions? Does anybody have any more questions? We are just over, it's 10:07, so we can answer a couple more questions if there are any more. Otherwise, we can bring the webinar to a conclusion. Oh, oops, keep doing that. Sorry about that. Let me give it a minute. In the meantime, Robert, I just want to thank you so much for always being so insightful and giving us guidance, because sometimes it's like so much and it can be so overwhelming. And we have one attendee that just said, thank you so much, great presentation. And a couple more people just thanking us. So again, Robert, thank you. We always appreciate you taking the time out of your very, very busy schedule. And I want to thank all of our attendees for your participation. We know how valuable your time is, and we truly appreciate your taking the time to join us. And we hope that all the information we bring you is useful and valuable. And we look forward to our first quarter webinar for 2023. If we don't speak again, hope you all have a wonderful holiday season. And we will be sending out information on our next webinar. Thank you, everybody.
Thank you. Thank you all.
All right. Thank you. Bye-bye.
Bye.